This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why fraud doesn't pay, but even when it doesn't, the fraudsters keep trying, and why the Eighth Circuit Court of Appeals determined that fraud perpetrators who attempted to get around a settlement with their victims failed because the court actually read the law. At one time, there was a Operation Backcracker, a joint state and federal criminal investigation that exposed a ring of Minnesota healthcare providers, mostly chiropractors, who were recruiting car accident victims and fraudulently billing auto insurers for their treatment. In related civil settlements, several providers agreed not to bill some of the insurance companies for any treatment to their insureds. The settlement agreement reduced the ability of fraudulent chiropractors who entered into the settlement agreements to profit from fraud against the insurers who settled. The chiropractors sued, seeking to void the no-bill arrangement used to reduce the insurer's losses by claiming the settlements violated the Minnesota No-Fault Automobile Insurance Act. The district court enjoined Illinois Farmers Insurance Company and others, together farmers, from entering into or enforcing the no-bill agreements and thereby voiding the settlements. In a case entitled Taqueria El Primo LLC et al. Versus Illinois Farmers Insurance Company et al., the United States Court of Appeals for the Eighth Circuit on July 31, 2024, in what it declared to be a question of first impression, whether no-bill agreements have the effect of providing managed care services or place pre-established limitations on medical expenses and benefits within the meaning of the No-Fault Act, and the Eighth Circuit resolved the issue. Plaintiffs represent both an injunctive class and a damage class of people insured by farmers. They sued after discovering that farmers had confidential no-bill agreements with a few providers, alleging that the state agreements violated the No-Fault Act. The No-Fault Act requires insurers to provide basic economic loss benefits when an insured is injured by the maintenance or use of a motor vehicle. Those benefits provide reimbursement for all loss suffered through injury, including income loss, replacement services loss, and medical expense. The no-bill agreements prevent providers from submitting bills to farmers or its insureds. In a typical agreement, the provider agrees not to submit, cause to be submitted, or seek payment on any farmer's claim for any services performed from the date of the settlement to a specific date, sometimes into perpetuity. Some agreements go so far as to clarify that bills submitted by the provider are void and that the provider may not collect the bills from farmers and or the insured claimant who received the treatments. The No-Fault Act does not create a private right of action, so plaintiffs sought an injunction under the Uniform Deceptive Trade Practices Act and damages under the Consumer Fraud Act. The district court granted summary judgment to the injunctive class and enjoined farmers from entering into or enforcing no-bill agreements. It ruled that the no-bill agreements have the effect of providing managed care services and set pre-established limitations on medical expense benefits, both violations of the No-Fault Act. And that meant farmers was in turn violating the UDTPA by certifying that its policies complied with the No-Fault Act when they did not. The phrase, quote, or has the effect of providing, close quote, broadens the meanings of the word provides and not the ends managed care services. The alleged program must be one that uses health care providers managed, owned, employed, or under contract with a health plan company. The no-bill providers, who make up a minuscule portion of Minnesota providers, are the only ones under contract with farmers, and the program excludes rather than uses them. This does not fit subsection 1C's express definition of a managed care program. If a no-bill provider complies with its agreement and never bills farmers or its insureds, the insured never incurs a medical expense. An insurer violates the No-Fault Act if it refuses to reimburse an insured who has incurred a qualifying expense. But an insurer does not violate the Act by enforcing a no-bill agreement against a provider because the injunction prohibits the latter. It cannot stand, and the injunction was vacated. In my opinion, the chiropractors entered into an agreement to avoid losses as a result of being caught defrauding insurers like farmers. By promising not to bill the insurers for the future, the insurers recouped their losses and incurred no new fraudulent losses from those providers. Attempting to break away from the agreement and continue to defraud the insurers, they sought an injunction against enforcing the deal they entered into. The United States District Court fell for the claim, and the Eighth Circuit saw through the scheme and vacated the injunction, proving to farmers and the other insurers involved you can't trust fraudsters. This video was adapted from my blog Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and you will have access to the more than 4,800 blog postings. You can also subscribe to the videos on YouTube and on rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. And please tell your friends and colleagues about this blog and the videos, and let them subscribe to the blog and the videos as well as you. If you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.